Some state constitutions explicitly use the word privacy. You have a right to privacy, like the California Constitution. But the federal Constitution does not use the word privacy. Now, the United States Supreme Court, for decades and decades now, has reiterated that there is, in fact, a right to privacy that is guaranteed in the Constitution. But they imply it, they infer it from the language of the Constitution. It's not explicitly there. And the way they infer that right to privacy now is in the Due Process Clause, something called substantive due process. Basically means there's a limit to what the government can do to the private individual. And the court says, look, if a right to privacy is something that is protected by that due process clause. Now, the word penumbra comes in. They don't use it much now, but a long time ago, when this theory of privacy was first being developed, it was developed because one of the justices said, well, privacy falls under the shadow or the penumbra of rights that are explicit in the Constitution. And so privacy comes in under those explicit rights. So people use the word penumbra as a way of talking about the way this notion of privacy was first developed. We've come a long way since then. Nobody really talks in the court about a penumbra anymore. They talk about substantive due process. When you hear that phrase, that's a long, cumbersome phrase, but it's the most important phrase for your personal freedom in this country. The phrase substantive due process. It means that there's a limit to how far the government can intrude into your personal liberties and your personal privacy. So, for example, in the Lawrence case, the court applied that inferred right to privacy. You can't open up the Constitution and read in the Constitution anything about sodomy or about same-sex partners.
Right.
But what you can read about is due process, and the Supreme Court has said inherent in that very, very general right that you have is a right to privacy. And that right to privacy applies to people's intimate behavior. So that's how the analysis is done by the Supreme Court to enforce privacy protections. And it all started with the word penumbra, but it didn't end there.